This is Joseph Dawson of the Dawson Law Firm. I am frequently asked what to expect after we have filed a lawsuit on your behalf. This video is intended to help answer that question for you. First, understand that we've only filed the lawsuit because the insurance company for the defendant has failed to make an adequate settlement offer on your case. This is not unusual, and you shouldn't feel too outraged. Insurance companies are in the business of making money, and the best way to make money is to not spend too much. We file suits on over half of our cases, so this is pretty typical. You are now the plaintiff, and the person or entity we have sued is the defendant. After the complaint is served on the defendant, they will file a response, which may contain claims by the defendant that they are not liable to you, or you have done things which may limit their liability. These are called affirmative defenses. I will discuss with you any such defenses which may have merit. Next, we will be responsible to respond to their discovery requests, which will usually be in the form of written interrogatory questions, a request that we provide documents, and notice of the taking of your deposition. We have limited time to respond to this discovery, so your cooperation is very important. And of course, we will assist you in the preparation of these responses, but do your best to provide complete and truthful responses. We will thoroughly discuss your case with you prior to your deposition, and all of the anticipated areas of inquiry will be discussed. I will spend more time on that subject as we get close to the actual deposition dates. The defendant is permitted to have you examined by a doctor they choose, who will testify for them at trial. These doctors are handpicked because of the fact that they are very defense-friendly with their opinions. Ultimately, we will attend a settlement conference, which we refer to as a mediation. At this conference, a retired lawyer or judge will monitor our discussions with all parties being present, either in person or by video conference. If we don't resolve the case at mediation, then we will proceed to a jury trial, which means a jury of 6 will hear the evidence, your testimony, your doctor's testimony, my arguments, their arguments, and then decide the case. Their decision is final. Here are some things to remember while we litigate your case. Be patient. Litigation is a marathon, not a sprint. Be accurate when you disclose prior injuries to the same body parts or other claims you have made. If you have treated for pain to the same body part that you've injured in this case, I need to know, as that information will most likely be in your medical records and they will find it. Don't go on social media. They will be looking for entries by you on Facebook and Instagram. Be careful with any activities in public. You are likely to be videotaped by a private investigator at some point during the pendency of the case. You should see your treating doctor from time to time if you still feel pain to document your continued symptoms. Feel free to call for updates on your case. I am available to discuss your case via teleconference, phone call, email, or texting. By working together, we can help maximize the value of your case and put together a strong trial presentation. It requires your patience, cooperation, and involvement. I look forward to working with you as we progress through these steps that I have outlined.